Hello, and welcome to this video lecture in your program on Advanced Legal Communication. My name is Tennille Duffy from Rainmaker, and in this video lecture for Unit 2, we're going to go a little bit beyond what's in the reading material. We're going to actually examine some skills and techniques that are useful to keep in mind when you're negotiating contracts. You might think that negotiation of contracts is all verbal. Actually, it's not, especially in these days of increasing use of emails and smartphones that have email on them. You'd be surprised at the number of back and forth that goes between solicitors or different parties when it comes to negotiating a contract in writing. Not to mention the different things that you need to keep written records of, even if you are having verbal discussions with someone. So let's go through some of the tips that I have for you today, and I'll try and give you some examples to go with each one. The first tip is that you should be the one to propose the language of the clause wherever possible. Now, you might think, well, hang on, why am I going to do all the work? Why am I doing the writing? I can make the other lawyer do it. Don't think of it that way. Think about the benefits that can accrue to you and your client if you're the one that does the drafting. You get to put things in the language that works best for you and your client, and you have more control over the deal that way. Sure, the other lawyer or the other party could propose their own wording, but it's much less likely if you've done the hard work. They're probably going to want to save some time, make it easy for themselves. So you be the one to propose the clauses or the drafting, or even prepare the entire first draft, wherever possible. The second tip is that you should always keep your client in mind. It's easy to get swept up in the deal, but you advise your client. You don't tell them what to do. You have to follow your client's instructions. This should be obvious to every lawyer, but as I said, it is easy to get swept up in it. The constant back and forth that can go with some contract negotiations is something that can very much distract you from the intent that your client wants you to put into the contract. And yes, of course, your duty is to advise your client. But at the end of the day, it's your client who's a party to the contract, not you. It's your client who needs to work within that agreement in the future of their business or their personal conduct. It's your client whose deal should end up in that contract. So always keep your client's instructions in mind. So for example, if your client is adamant that they don't want a particularly longer cooling off period, you should advise them, take the full 30 days. The other side, no. If they don't want that, if they are adamant that they want only 15 days, well then that's what you should put in the contract. By all means, keep a record of the fact that you've given advice to your client, but put your client's instructions in force in the contract. The third tip is really an extension of the second, which relates to having the right knowledge. You need to know what your client wants. You need to know what the other side wants. You need to know the contract. That is, if there is a draft or if there's some kind of standard form contract in the area. And you need to know the bottom line. At the end of the day, knowing all of those things before you start negotiations will help you, hopefully, come up with a win-win situation for your client and the other party. And when I say you need to know what the bottom line is, you need to have had a thorough discussion with your client before you commence drafting a contract and also before you commence negotiations. You need to know the things that your client is just not willing to negotiate on. And you also need to know the things where your client might be willing to give some more room or leeway to the other side, some things they might be willing to give up in order to get something from the other side. So have that knowledge and have all of those things in mind before you begin negotiations, and your negotiations will be quicker, simpler, and you'll be putting your client's instructions into force. The next tip is that you should never agree to anything that you're not sure of or that you don't fully understand. Now, I hope that this is a very obvious tip. I almost shouldn't have to say it. But you would be surprised at the number of clauses that end up in contracts where lawyers aren't really sure, the language is something they're not really familiar with, but they think it has to go in, or they listen to the other party's solicitor when they say, no, that needs to go in the contract. There's nothing wrong with saying that you need some more time or that you need to discuss something with your client before you put it in the contract or before you agree to it remaining in the contract. Ensure that you do that, and it can be quite disastrous if you do agree to something that you're not sure of, because it's much harder to back out afterwards. The next tip is that you should put things in writing, and by that I include instructions from your client and seeking confirmation, and also keeping a record of all your drafts and revisions. So really, even when you're having verbal conversations with your client, you're having conversations with the other party or their solicitor, you should immediately record some notes about those conversations in writing. And if in the course of that conversation you've agreed to something or you've proposed something, put it in an actual letter to the client or the other side and seek their written confirmation in response to that. It's also important that as you're drafting and redrafting clauses, they're going back and forth between the other lawyer and yourself, you need to keep a clear record of all the revisions and changes being made. That's important not just for you and your records of the matter so that you can look at what's happened if you have to pick the file up a week later. Also, in a lot of cases, there will be more than one lawyer involved in a deal. You might work in a large firm, someone else might need to pick up the file, you might get sick one day, but someone is still able to continue the negotiations and still keep assisting your client if you've kept proper records. So ensure that you keep your notes and you keep records of your drafts and revisions. The next tip to keep in mind is that you should remember that any negotiation will hopefully result in a contract and therefore a relationship between the parties. You want that to be a trusting, working relationship, not an acrimonious one where the parties treat each other with suspicion and don't trust each other. So basically, be nice, be courteous, be professional in your dealings with your client, with the other party, and with their solicitor. By acting in that professional manner, you'll be fostering the kind of relationship that your client can work with in the future. After all, that's what a contract is about. Most often, contracts are about forming a relationship and agreement between two parties that can operate into the future for as long as the contract needs to. And you will be doing nothing but assisting your client by promoting that kind of relationship with the other party. Thank you for watching. In the next unit, we're going to move on to looking at writing memos and in particular, how we incorporate some of our research into our legal writing.